অর্ডারগুলো একটা বাঞ্চ করে সুপ্রিম কোর্টে গেছে, সুপ্রিম কোর্ট থেকে ফিরেছে, সব আছে তোর কাছে? আছে সব আছে আমার কাছে, সেই জন্য পাঠিয়ে ফিরেছে। এই যে এমএডি 930 সব আছে ইন্টারিম অর্ডার আমার কাছে। এক মিনিট তাইলে কতটা অর্ডার দেখছি না। ইয়েস now that 7 July order, Mr. Dotto, yes, that is the order passed by the Supreme Court against the appellate court order staying the operation of Justice Gangapathan. Right. But there is reference to another order of 4th July 23. I don't know. That I couldn't find. Well, what I am suggesting is, either Mr. Lahiri takes this responsibility, but I take the first responsibility, or Mr. Vishwas. And I'll sit with them, get all the orders, each sequence. There is that after your submission, you will hopefully complete it today. No. আজকে করে দিই। You will complete it today, and we will hear the counsel who is supporting your contention.
My lord, if I may, there is a 7th July order of the Supreme Court, Honorable Supreme Court. That is my appeal, my lord.
Madam, we are not wanting to know whose appeal is it. We are wanting
to know who will argue, who will be the counsel who will argue.
Yes.
That is, my lord, I was the one who went to Supreme Court with this is my SLP, my lord. So this is my request before your lordship that we may be heard.
So where we have said that we will not hear it? Have we said that we will not hear it? Repeatedly you are raising the same point. Yes, Mr. Dotto. Yes. Please, I have given it to your mind. You please equal. Before the returnable date, we'll prepare a compilation of all the orders, starting from the Honorable Single Judges, all orders, and the Supreme Court as well as the Division Benches order. Yes. Now, on the last occasion, when I was addressing this tribunal, this Honorable Court, on the aspect of corruption, the judgment proceeds चार सुप्रीम कोर्ट केसेस लास्ट दिने दिएছি এটা একটু বের করে রাখো 23/4/731 2023 Yes, as regards corruption. Right. You have referred to Black's Dictionary, yes. State of UP versus Vedpal Singh, okay. Chhadia versus State of Madhya Pradesh, State of Andhra Pradesh versus Basudev Rao, Joint Action Committee, Neeraj Dotto, yes. Kim Wangsu, yes. And Deepa Bhai Nanu Bhai Sanghania. Right. That's it. Now, my lord, since the judgment proceeds on the basis of a potential corruption, where I use this expression potential because the entire presumption was that of a corruption. We have taken note, yes. Mr. Dotto. Now, my lord, yes. Since, my lord, everything has been invalidated on a finding of corruption. My lord, the Supreme Court in Neeraj Dotto's case, which your lordship has been pleased to take note of, my lord has Yes.
Millard has discussed in details.
That you have shown us paragraph 22, Neeraj.
Yes, Millard, that is Millard only one of the findings. But what was the Supreme Court or the larger bench considering? What was the reference and what is the ultimate finding on an issue of corruption? That Millard I need to Millard place before your lordship.
Further judgments, Mr.
No, this is same judgment. The same judgment.
Tell us which paragraph you want.
Yes. Kindly take Millard the first paragraph.
Yes. Paragraph?
Millard, paragraph number 1.
Yes.
By an order, a 3-judge bench of this court has referred the question of law framed to be decided by a bench of appropriate authority. That is how this batch of cases has been referred to the Constitution bench comprising of 5 judges. For easy reference, the order of reference is extracted as under. Your Lordship may skip over point number 1 and 2 or reference number 1 and 2. Please take reference number 3. Noting the divergence in the treatment of the evidentiary requirement for proving the offence under section 7 and 13(1)(d) and 13(2) of the Act, the court referred the following question of a law for determination by a larger bench. The question whether, this is Millard, how Millard, the question is framed. The question whether in the absence of complainant stroke, direct or primary evidence of demand of illegal gratification, is it not permissible to draw inferential deduction of culpability stroke guilt of a public servant under section so and so based on the evidence adduced by the prosecution? Where the reference, Millard, is in the alternative or in the negative, that where there is no direct evidence, can corruption be proved through indirect or inferential evidence? We are in a case where there is no direct evidence. Therefore, how a charge of corruption or corruption as a facting issue is to be considered is the subject matter of reference, and Millard, the Honorable Supreme Court, Millard, in various paragraphs deals with it, and Millard finally comes to the conclusion at paragraph 88. Now, one more paragraph is paragraph 3. With the other part, I am not troubling your Lordship, Millard, may not be relevant for me. Thus, paragraph 3, Millard, next page. Thus, the moot question that arises for answering reference is, in the absence of the complainant letting in direct evidence of demand, owing to non-availability of the complainant or owing to his death or other reason, whether the demand for illegal gratification could be established by other evidence. This is because in the absence of proof of demand, a legal presumption under section 20 would not arise. Thus, the proof of demand is a sine qua non for an offence to be established under section so and so, and beholds the proof of demand, the offence under the 2 sections cannot be brought up.
Yes.
Therefore, my lord, in view of the essential ingredient, or my lord, the sine qua non, that my lord, there has to be a demand and acceptance or delivery of an illegal gratification, whether through inference or through circumstantial evidence, that can be proved.
So your argument is, in the absence of direct evidence, you cannot even infer that there has been
you can infer, but the parameters are laid down later on. The Supreme Court was considering there is no direct evidence.
Now, those parameters, which paragraph?
Yes. Now, my lord, if my lords may kindly take me, lord, paragraph 46.
But Mr. Datta, the word corruption was used in the judgment.
Yes. Yes. Where the word corruption has been used without any evidence.
No.
Direct, indirect, nothing.
So far as
Milord,
be wrong,
corruption, Milord, by itself.
it was a passing remark. Can you
Yes.
come back to page 622 of the paper?
Well, I'll come back to that, Milord. Yes.
You may argue that on the basis of a passing remark, you could not have interfered with the 36,000 account.
Yes,
Maybe you, that is
yes,
it.
finally that.
So, except in page 622 penultimate line,
Yes.
there is no other reference. A corruption of this magnitude is never known in the state. This is his lordship's remark. So on the basis of that, how corruption of this magnitude, because the education minister was taken into custody. And now, and on the basis of that, his lordship concludes that the entire selection process.
Yes. Now, yes. Before that, my lord, please take paragraph 18, 19.
These
Yes.
are remarks. These are
No. It is please take my para 18 at page 623. It is a matter to be noted that the board in its affidavit in opposition while dealing with all the pleadings of the petitioners, instead of addressing the allegation of corruption and illegalities in the recruitment process, raised some niceties of law and some principles of law. But however nice or however laudable those principles may be, this court as a court of justice will fail to deliver justice, knowing fully well that sense of justice is much above sense of law. If the writ application is thrown out on such niceties of law as this will mean, in the name of preserving the law, the corruption would be protected, which a constitutional court can never do, keeping in mind the soul of our constitution and the constitutional conscience. I must say, in this recruitment scam, stinking rats are being smelled. Therefore, with respect, it's not a passing remark, but it is the basis of the judgment. The basis of the judgment is, where there is corruption, don't bring in niceties of law. Then kindly take my paragraph 19, which my lord please to refer.
yes.
The board placed some judgments before me in support of niceties of legal principles, which I do not find have any applicability in the face of the magnitude of the stinking corruption in the recruitment exercise of 2016 conducted by the board. Those judgments are not required to be mentioned at all in the factual situation of the case, as those are bright stars, etc. Factual situation of the case. Now, what is the factual situation of the case?
That which has been ascertained upon taking evidence.
Yes. Well, I'll deal
You deal 165 now. You have finished your argument. Now you
165, of course, well, I'll have to deal with it. Well, whether at all 165 is applicable or not.
Yes.
If applicable, how it is to be applied.
We are expecting that argument.
Yes. But Milord, please take Milord, since Milord...
paragraph 3 you have shown us.
Yes.
Yes, any other paragraph?
Yes, now if your lordships may kindly take Milord, please take Milord paragraph number 46 onwards, a few paragraphs.
46 you did not place, Mr.
No, I have not yet placed Milord.
You placed para 22.
Yes. Milord, on the earlier round, Milord, I have not placed these paragraphs.
Yes, what do you want to show?
Now, question for consideration. First, Milord, I have shown the reference, Milord, at paragraph 1 and 3. Now, question for consideration is at paragraph 45.
That is repetition of paragraph 3. Paragraph 1 subclause.
Right.
Paragraph, yes.
On consideration of the aforesaid cases, the question framed for determination by the larger bench is whether, in the absence of evidence of the complainant, direct or primary evidence of demand of illegal gratification, is it not permissible to draw an inferential deduction of culpability, guilt of a public servant under section so and so based on other evidence adduced by the prosecution? Paragraph 45.
Yes, that is the reference point.
Yes. Now, my lord, the Supreme Court is, my lord, because, my lord, I was not required to place this judgment. Had the Honorable Single Judge not taken recourse to Section 165 of the Evidence Act, by reason of adoption or taking reference to Section 165, where the whole procedure or the scheme of the Evidence Act is required to be placed before this court as to how an allegation of corruption is to be proved. Where corruption is something, my lord, which vitiates everything. No doubt about that. But by merely saying, by merely inferring, by merely
What are the
smelling.
parameters you show
Yes.
us?
First, kindly take my paragraph number 47. Since the main thrust of this case is on the quality of evidence for proof of demand and acceptance of illegal gratification before a public servant can be held guilty under section so and so, it would be appropriate to discuss the salient principles of law of evidence relating to the question under consideration. In this context, it would be necessary to refer to sections 3, 4, 59, 60, 61, 62.
Now, which paragraph it has been summarized?
Yes. Milord, everything is considered from Milord. I kindly note it down. I will not waste the time of the court. Kindly note down the paragraphs. Milord, your lordships may kindly consider.
Paragraph 88 ultimately.
Yes, ultimately. But Milord, before that, I am not placing those. Kindly note down these paragraphs.
Yes.
Paragraph 48,
Yes.
49, 50, 51, 53 is very important. Here, Milord, the Supreme Court is considering circumstantial evidence. 54, 55, 56. 56 again is important because oral evidence is being considered. Here, my lord, the Honorable Court, my lord, had called, my lord, certain witnesses. Then, my lord, your lordships may skip over 57, 58, 59, 60, 61, 62, then 64. May I place 64, my lord? Then I'll go to, my lord, 88. Courts are authorized. Courts are authorized to draw a particular inference from a particular fact unless and until the truth of such inference is disproved by other facts. The court can, under section 4 of the Evidence Act, raise a presumption for the purposes of proof of a fact. It is well settled that a presumption is not in itself evidence. This is very important. But the entire judgment now proceeds on presumption. But only makes a prima facie case for a party for whose benefit it exists.
All right.
Lord, a court can definitely presume something, but the parties have to come and prove it or disprove it. As per English law, there are 3 categories of presumption. I don't trouble your lordships with those. Then, my lord, skipping over, my lord, 66, 67, these are all judgments, my lord, which has been my lord, considered by the Supreme Court. 68, these are all previous judgments. I don't trouble the court. 69, 70, all previous judgment. Then, my lord, 71, kindly note down, my lord, your lordships may consider it, my lord, at the time of delivery of judgment. Now take, my lord, 73.
Yes.
It is tried law that in cases dependent on circumstantial evidence, The inference of a guilt can be made if all the incriminating facts and circumstances are incompatible with the innocence of the accused or any other reasonable hypothesis than that of his guilt, and provide a cogent and complete chain of events which leave no reasonable doubt in the judicial mind. But the cycle or the chain has to be complete. In a case of inference, and Millard, a case based on circumstantial evidence. Then Millard, after all these Millard, now Millard, your Lordships may kindly come to paragraph number 88.
88 you placed, 88.3,
Yes,
88.5 you
Yes.
gave.
88.1, 88.3, 88.4 and 88.5. Now, but in this backdrop, what Millard I have just cited Millard the various paragraphs. Now kindly see Millard what is the final Millard outcome or conclusion of the Honorable Supreme Court. What emerges from the aforesaid discussion is summarized as under: proof of demand and acceptance of illegal gratification by a public servant.
You placed it, Mr. Datta.
Therefore, first is, may I summarize what the Supreme Court summarizes? Number one is proof of demand and acceptance is a sine qua non. That your Lordship will not find a sentence in the judgment under appeal to that effect.
Yes.
Then 88.3 is it can be proved also by circumstantial evidence in the absence of oral and direct evidence and documentary evidence. And
8 o'clock, 11 o'clock. Yes.
then we're 88.4.
Yes.
How to demand an acceptance? In order to prove the fact in issue, namely the demand and acceptance of illegal gratification by a public servant, the following aspects are to be borne in mind. If there is an offer to pay by the bribe giver without there being any demand from the public servant and the latter simply accepts the offer and receives the illegal gratification, it is a case of acceptance as per section 7. In such a case, there need not be a prior demand by the public servant because there is an acceptance. 2. On the other hand, if the public servant makes a demand and the bribe giver accepts the demand and tenders the demanded gratification, which in turn is received by the public servant, it is a case of obtainment. In case of obtainment, the prior demand for illegal gratification emanates from the public servant. That is an offence. 3. In both cases of 1 and 2 above, the offer by the bribe giver and the demand by the public servant respectively have to be proved by the prosecution as a fact in issue. But with respect to the entire scheme of the law has been completely bypassed. This is not a magic word, corruption, that can be used and any actions can be negative. Because the consequences are serious. In a case of an allegation of corruption, my lord, the consequences are very, very serious. Therefore, my lord, these strict principles, my lord, are to be applied. And merely presuming corruption, smelling corruption, my lord, these cannot, my lord, form the basis of a judgment.
Yes.
Well, one more subparagraph, 88.5E.
Yes. Yes.
88.5. The presumption of the fact with regard to the demand and acceptance or obtainment of any illegal gratification may be made by a court of law by way of an inference only when the foundational facts have been proved by relevant oral documentary evidence and not in absence thereof. So this is a bar on court to presume corruption, whatever may be its magnitude. But in the absence of, my lord, any proof. And how to be proved? Oral and documentary evidence, and in absence thereof, you cannot infer corruption.
Yes.
My lord, your lordships have read the judgment under appeal. I will not trouble your lordships once again with that. But my lord, the judgment, my lord, proceeds absolutely on the basis of inference, without any proof, without any adherence to the parameters which has been in fact collated in this judgment. But these are all section-based discussion, and earlier judgments have been referred. Maybe this Supreme Court judgment has come after the judgment under appeal has come, was delivered. But here all the judgments which have been referred are previous in point of time. Therefore, these being the parameters,
Yes.
well, my respectful submission is, no corruption has been proved in the manner, required by law, and therefore, the learned judge could not have accepted an allegation of corruption. Now, what is the allegation? I'll come to that later on. And therefore, this judgment should go.
Anything else, Mr. Datta?
But I have got 7-8 points more, Miller. But please only note down the paragraph numbers, Miller, where your lordship will, have a look at it, Miller, at the time.
Refer further judgments.
On corruption, I'm over. But only the paragraphs in the writ petition, kindly note down the paragraph numbers. On corruption. Then, Miller, I'm done with corruption issue.
That you have already placed.
Very good. Paragraphs 12, 14, 15, 17, 18, 22.
That you have earlier shown us.
Yes, yes. Very well. Very well.
When you were arguing on absence of pleadings, that was done. What else, Mr. Dotto, you want to say?
But the next point is, my lord, that, my lord, your lordships have held in innumerable number of judgments that a writ petition is not meant for a roving inquiry.
That you have argued.
No, my lord, a few points.
That is covered in Justice Shilpukar's order, which you have placed.
No, my lord, hello, Jordan. Yeah.
That paragraph is there, roving inquiry.
Yes.
You have argued.
Very well. But, my lord, that is, my lord, the principle that I've argued. But, my lord, the applicable facts, my lord, kindly just, my lord, note down the orders on which, my lord, I.
Yes, which?
My lord, first is, my lord, the order dated 6th of December 2022.
That is on the first day you argued. That see the backdrop.
Yes, yes.
On
Just
what
note down
basis?
the where I'm not placing it. I'm my lord, trying to, my lord, assist your lordship, my lord, on each point. What are the documents or paragraphs that I intend to, my lord, rely?
বললো না সেদিনকে হ্যাঁ বলে দিয়েছে yes
Lord, on the roving inquiry part, my lord, I refer to, my lord, the order of the learned single judge dated 6th of December 2022.
yes
Then 20th of December 2022, my lord, I am being asked to disclose documents.
Yes, you have placed these.
Yes, just note down the orders. Then we got 7th of January 2023, 24th of January 2023,
Hmm.
and 5th of April 2023.
Very good.
Yes. But these are, my lord, the orders from which, my lord, my lord, respectfully submit that this was an exercise of roving inquiry, my lord, under Article 226. My lord, 3 judgments on this. Kindly note down the citations and the paragraph numbers.
You have given it earlier.
My lord, Sadananda, hello, my lord, I had relied, my lord, on what should be the approach of the court in a case of...
Further judgments you are giving.
Yes, on the roving here, three judgments only. But on roving inquiry, my lord, I made my submissions, but I don't think I placed any judgment.
Just tell us which judgments you are saying.
My lord, 2008, Volume 4, Supreme Court Cases 619.
Yes,
36, 37,
place that is Sadananda.
Paragraph 58.
and 58, 60,
Yes.
60.
Yes, you have placed.
Then, my lord, 2012, 3 SCC 236.
12, 3 SCC.
2012, 3 SCC 236.
এটাও করতে গেলাম। In roving inquiry, you cited the 2010 volume 11 SCC 6, 9 and that Ugra Sen judgment.
No, that is, my lord, relief granted, not prayed for.
And
That is relief granted.
in the absence, no inquiry can be, no such roving inquiry can be made. That was Ugra Sen.
Yes.
When there is no pleading to that effect,
The absence of pleadings, this order could not have been passed. That
not have been passed.
Right. Now, my lord, I am saying that fishing and roving inquiry. Just note down the citation, but I will not detain the court. I don't, my lord, please don't have the feeling that I am detaining the court, my lord.
2012,
2012, 3
That-
SCC
that's it.
236.
Do you get that sort of an idea? We are hearing you for the last 3 days. Yes, 2000.
2012, 3 SCC 236, para 35. And 2007, 8 SCC,
Just a moment.
I'm sorry,
236 paragraph 5 and 2008 SCC.
my lord, 2012, 3 SCC 236, para 35. And 2007, 8 SCC 418, para 83.
2007.
7, 8 SCC 480.
What paragraph?
This is paragraph paragraph 83.
30. এই কোনটা না? একটু লিখে দাও না, আগে দাও। তো এটি 20-25 তো দেখিয়ে দিয়েছে। Yes.
Yes, yes, sir. 165.
যেহেতু এইসব বন্ধ Hmm. Yes. Yes, Mr.
But my first submission is, Milord, this is not a case, Milord, where, Milord, section 165, powers under section 165 could have been exercised.
165 cannot be gone into.
Cannot be exercised in the case which was being, Milord, dealt with, Milord, by the learned single judge.
ঠিক
না।
এভিডেন্স একটা চলে গেছে yes yes
Well, number 2 is, Milord, that section 165, Milord, supplements various provisions of the Civil Procedure Code as well as the Criminal Procedure Code.
yes
Number 3 is made only in a case of trial. 165 is exercised by the court, Milord, for eliciting, Milord, some important issues which may have been missed by the prosecutor or the defense. Here, Milord, the court has acted as a prosecutor, Milord, in calling witnesses and examining the witnesses.
yes
But here, Milord, the court has, Milord, using the language of the courts, Milord, not my language. Here, Milord, the Honorable Judge has, Milord, trespassed into, Milord, the shoes of the prosecutor and the defense.
that you have independently argued that he has acted as a prosecutor.
Yes.
So you
Milord, kindly note down the orders on which I rely. I have placed all those, just note down the orders. Where, Milord, the court has exercised powers under section 165. Where the orders are dated 17/1/2023,
yes
page 421 of the paper book. Then 24/1/2023,
yes
page 423 of the paper book. Then, Milord, order dated 6/2/2023 at page 427 of the paper book. Well, kindly, Milord, note, Milord, one feature where in this order at page 427, the court is selecting the witness.
yes
Then the order of 21st of February 2023, so that page 432. Then order of 5th of April 2023 at page 436. And, Milord, lastly is, there are two orders of 5th of April. The second order of 5th of April 2023 at page 437.
yes
Now, Milord, 4 or 5 judgments on this way. These are all, Milord. I have in fact reduced the judgments on 165, which I had cited before the Honorable Single Judge, but unfortunately, Milord, the Honorable Court felt that these are niceties of law and should not be referred even. The first one is AIR 1968 Supreme Court, page 178. ওখানে কি দেখছিস?
Paras?
68. Paragraph 5, 6. হ্যাঁ? Okay. এটা সব আমি স্ক্রিন করে নিয়েছি, থাকবে এটা।
Yes.
Online citation of that 67. 67 SC online SC finish. দাদা support করতে With 165 is quoted over here, therefore I don't trouble your lordship with the book.
Quoted where? Oh,
The judgment itself. Therefore, I don't take your lordship to the book.
yes.
So please take me paragraph number 5.
67 SCC.
The question falls to be considered under section 540 of the Code of Criminal Procedure. That section is to be found in chapter 46 of the code among several others which have been appropriately described in the heading to the chapter as miscellaneous. It provides 165, the judge may, in order to discover or to obtain proper proceeding under this code, summon any person as a witness or examine any person in attendance, though not summoned as a witness, or recall or re-examine any person already examined. And the court shall summon and examine or recall and re-examine any such person if his evidence appears to it essential to the just decision of the case. The section gives the power to the court to summon a material witness or to examine a person present in court or to recall a witness already examined. It confers a wide discretion on the court to act as the exigencies of justice require. Another aspect of his power and complementary to it to be found in section 165 of the Evidence Act, which provides
Yes.
the judge may, in order to discover or to obtain proper proof of relevant facts, ask any question he pleases in any form at any time of any witness or of the parties about any fact, relevant or irrelevant, and may order the production of any document or thing, and neither the parties nor their agents shall be entitled to make any objection to any such question or order, nor without the leave of the court to cross-examine any witness upon any answer given in reply to such question. These sections between them confer jurisdiction on the judge to act in aid of justice.
Which
But
is
one
the-
thing that I have missed, Millard, in paragraph 5, the fourth line, the 165 is a misprint. It should be section 540. Kindly, if your lordship may kindly make the
540.
correction. In paragraph 5, in the fifth line, 165 is quoted, but actually that is 540 of the,
Yes, the sentence begins with that.
yes. So it's kindly Millard, correct that, where it's a misprint in the judgment.
This is 540.
That is 540.
Yes. Now, what is the summarization? Which were?
Today is also.
Yes, any other judgment?
Okay, please give me a moment for that. But the next one is 2004, volume 4, Supreme Court cases 158. There are two paragraphs from this judgment, 43 and 44. Paragraph 43 and 44 below, only two paragraphs from this judgment.
We shall go through it. You can give us the
Very well.
crux of the principle, you can tell.
So the crux of the principle over here is where the object of section 1625 is, in my method, a humble understanding, is to elicit some important fact in issue. Nothing else.
So why do you say that it cannot be applied by the judge?
Well, in a case of trial, Milord, I am, say, Milord, the cross-examiner. Milord, I am cross-examining, Milord, my other side's witness.
No, you have any authority that 165 cannot be allowed in a writ petition?
Milord, 165 is never contemplated in a writ petition.
That is what you are asking.
That Milord, that is, Milord, what I intend to submit before the court. There is no, Milord, I have not been able to find out any judge, lay my hands on that. Because trial, Milord, it is,
No, suppose something is suspicious to me. I cannot ask you, Mr. Dotto, that you please come and depose and tell us.
Number one is that, Milord, a writ proceeding is a order 19 proceeding. Here, Milord, your lordships decide on the basis of affidavits. Whatever is annexed to the affidavit or the writ petition, they are considered as evidences.
Evidence.
Evidence. Milord, normally, Milord, your lordships decide on the basis of whatever is placed by way of affidavit evidence. It is not that the court is debarred from taking evidence. In an appropriate case, Milord, there are judgments which say that yes, evidence can be laid before the writ court also. In those circumstances where the writ court will, Milord, invite the parties to lead evidence. So the parties have to come, produce their witnesses, lead evidence where the writ court feels that this is such an extraordinary case or an exceptional case where the writ court should step out from the normal procedure and invite the parties to adduce evidence.
But the court cannot call anybody and say that give evidence. Is what you want?
Yes, in my respective submission, no. Please take the next case that I intend to cite.
No problem.
This is number 81 3 SC 191.
Yes, whereas
The two paragraphs, paragraph 2 and 3. Akashi 3. না না 81 ঠিক আছে রামচন্দ্র হ্যাঁ So please take note paragraph number 2.
কি ইন্সপেক্ট করে গেছে কি ইন্সপেক্ট করে গেছে দেখতে চাইছে সাপ্লিমেন্টারি এভিডেভিটের একটা কপি ইন্সপেক্ট করবো এই অগ্রজিৎ আসেনি তো Yes, paragraphs 3 and 4. 2 and 3.
The adversary system of trial being what it is, there is an unfortunate tendency for a judge presiding over a trial to assume the role of a referee or an umpire and to allow the trial to develop into a contest between the prosecution and the defense with the inevitable distortions flowing from combative and competitive elements entering the trial procedure. If a criminal court is to be an effective instrument in dispensing justice, the presiding judge must cease to be a spectator and a mere recording machine. He must become a participant in the trial by evincing intelligent, active interest by putting questions to witness in order to ascertain the truth.
That is in a criminal trial, you said.
Any trial, here it is a criminal case. Here indeed it is a criminal case. As one of us had occasion to say in the past, every criminal trial is a voyage of, can you skip over that? Then please take me to para 3. With such wide powers, the court must actively participate in the trial to elicit the truth and to protect the weak and the innocent. It must of course not assume the role of a prosecutor in putting questions. This is what the Honorable Judge in my very respectful submission has done in this case. The functions of the counsel, particularly those of the prosecutor, are not to be usurped by the judge by descending into the arena as it were. Any question put by a judge must be so as not to frighten, coerce, confuse or intimidate the witnesses. The danger inherent in a judge adopting adopting a much too stern an attitude towards witnesses has been explained by Lord Justice so and so. Now kindly, so far the quoted part is concerned, please turn the page. At page 194, the quoted portion, please take the 4th line from the top. The 4th line from the top, the quoted portion. If he, where he means the judge, if he goes beyond this, he drops the mantle of the judge and assumes the role of an advocate, and the change does not become him well.
So in this case, what the judge has done?
The judge with respect to played the role of a prosecutor. None of the parties called witnesses. None of the parties were either examining or cross-examining any witness. Rather, the Honorable Court records that none of the parties have put any question to the witness, which is recorded in the order dated. The orders that I have not placed, 21st February 2023 order, the court records that no question has been put by the parties. Then what is the result?
Parties includes you.
Everybody.
You did not question that.
No, it's not my witness. It's not my adversary's witness also.
You are the respondent. If any evidence is against you, you will not cross. Ask the judge to say that allow me to cross.
The first is whether a trial was being held on.
No, that is separate. That is separate.
Unless there is no
You are party to that, you did not cross.
Question is, do I commit this mistake by asking any question and transform it into a trial or not?
No, that is your wisdom, Mr. Dotto. That is when a trial goes on, certainly
there is no trial.
No, trial in the sense
Then I need to place the orders once again, these 5 orders.
No, by trial what do you mean?
Milord, trial, Milord, so far as the criminal, I'm sorry,
Don't restrict it to criminal. It is in respect of all proceedings.
Milord, so far as the civil case is concerned, Milord, after the issues are framed, Milord, this is examined, thereafter, Milord, the trial begins.
Very
In
good.
a criminal case, Milord, post cognizance, trial begins.
No.
Neither of these, Milord, procedures, Milord, are adopted in writ court, not in this case. Milord, I can understand, Milord, from the very beginning, Milord, the court was either following the CPC or following the CRPC, considering it as a civil case or a criminal case requiring trial.
Which order did you say, or date of the order?
Milord, the order, Milord,
They did not put questions, none of the parties.
page 432, order dated 21st of February 2023.
Very
That is 430.
21st February.
yes. আরো কিছু আছে না?
Then we have the answer.
Yes, yes.
So take a civil case. The next one, 1971, 3 SCC 303. This is made in an election dispute matter.
You said you will provide 3 judgments.
71, 3 SCC 303.
Oh,
Dipanshu Arora. So this went from the airport. Please have a look at one paragraph.
wow. Yes, para?
In that paragraph 12 of this judgment. Paro.
Yes.
The
Correct.
paragraph 12, the part of it where I'll place. Another feature,
Mr. Dotto, please, if you can summarize a bit, otherwise we can never finish.
but that's why I'm reading part of a paragraph. But I'm not reading it in its entirety. But only to demonstrate that when or how 165 is
Which line, from which line you are placing?
Milord, I am placing, again we have to shorten it further. Please take the 6th line of paragraph 12.
No doubt.
No doubt under section 165 of the Evidence Act, a court has got power to put any question it pleases in any form at any time to any of the witnesses of the parties about any fact relevant, irrelevant, but that power is to be exercised in order to discover or obtain proof or proper proof of relevant facts. So, when witnesses are produced by the parties, trial is going on or examination, cross-examination is going on, the court definitely has a power under 165 to elicit some important aspect of the matter. It may be relevant, it may be irrelevant also. For the judge, it may be important.
Yes.
But just only half sentence, please take what our High Court has held in 1953. 1953, SCC Online Calcutta 181. Sunil Chandra Ray.
Para.
Please note down the paragraphs, but I'll place here only one sentence. Your paragraphs are 30, 36, 37 and 75, but I'll not place all these paragraphs. Please take its paragraph. The most important of these are paragraph 36. Can you have a look, Miller? So please take Miller printed page 18, 1/8.
हाँ उधरेली होती ले
Please take the fifth line at printed page 8, which is part of paragraph 36. I do not think. I do not think, yes, I do not think that there is any point in this criticism, because the criticism was that the judge has introduced new point. Criticism because if the prosecution omits,
Para 36.
36, I am not reading in its entirety. Please take note the next page, para 36 starts from printed page 17.
Yes.
Please come to page.
I do not think.
I do not think that there is any point in this criticism, because if the prosecution omits to bring out a material fact, or the cross-examining counsel brings a witness to a state in which he cannot make his meaning clear, I do not think that defense acquires a vested right in such omission or confusion which the judge is not entitled to disturb. It is precisely for use on such occasions that the judge's powers under 165 are intended. The 165 is not intended for a whole hog trial, where the judge will participate from the beginning to the end. Then the last on this is Mukti Ghosh, 1974, SCC Online, Calcutta 139. So please take paragraph 4.
Yes.
The question then is whether any omission on the part of the prosecution to fully examine any witness of his due to his remissness or inadvertence can be made good and if so, how? The arms of law are long enough to provide for a contingency of the above nature. The provisions of law are those in section 549 of the code and section 165 of the Evidence Act, one being complementary of the other. These two sections between them confer jurisdiction on the judge to act in aid of justice.
Yes.
That was 549.
Same, repeated, same.
Then para 6.
You have placed that.
The judge may act under section 165 of the Evidence Act in order to discover or obtain proper proof of relevant facts
Yes.
by any question he pleases in any form at any time of any witness, so and so.
All right. Any point you leave out, Mr. Dotto, you will get a chance to reply and come back to us. Let us get the
Then
feel
your
of that.
Lordship may kindly collate the points, my lord, which I intend to submit.
Yes.
3 or 4 points, my lord, I have already argued. Whatever I have argued, my lord, I will not put those. But the next point, my lord, is, my lord, on the aptitude test part, my lord, where, my lord, the learned judge, my lord, has held that no aptitude test was held. Though, my lord, there are evidence galore, my lord, before the court on that aspect. Please note down the pages which I intend to, my lord, rely on this. First is the learned judge, my lord, has come to the conclusion that there was no engagement letters of the interviewers. According to the learned judge, my lord, they were called over telephone. This is what has been held at page 617.
Yes.
Page 617, but after that table,
617. 617. Yes.
So the first 3 lines is no questions was put to the interviewers. Then after that, the 4th line, it is to be noted that there was no formal engagement letters for acting as an interviewer. All the interviewers were called for whom to take such interview.
लोग बड़ी बेचते ये पापा हाय अरे
No pleading to that effect, no evidence to that effect. Then please take B.
ये माये तो घाव उड़ा मारा है
Yes.
B is there was no guideline for awarding marks for aptitude test.
You have placed this.
Yes, yes. Yeah, point wise only indicated. I know I have placed the entire order. A, B, and C. But I have all the interview letters, the engagement letters of the interviewers with me. But now nothing was before the court because these points did not arise. There is no pleading in the writ petition.
So you did not argue also.
Because there is no scope of any argument. Where, number 1 is there has to be a pleading.
That all right, but
Number 2 is there has to be an argument by my friends on the other side also. If something is not argued, I will not jump and will not contradict that.
no. These 3 points has been taken. This is in this regard. Court passed an order on 6th of February 2023.
Yes.
That order you did not challenge. That way the court proceeded. That these observations were there in the order of 6th of February 23. You did not challenge that.
I did not challenge it is one thing, but there has to be some argument, Milord.
That argument is there. This is the judge proceeds on this basis.
What will divorce any argument? There has to be some oral argument. I mean, I have got much to say on how the proceeding was conducted. I would not like to go through to that extent. But here your lordships will not find what arguments were advanced by the petitioners.
So where you shut down from making argument?
But could I say this, Milord? It is not possible. Please consider one thing, Milord. I take the writ petition, first sentence, this is my answer. I take the second sentence, this is my answer. I take the third sentence, that is not how we argue cases before the court.
No, the judge proceeded that I made these observations in your presence. And if that was derogatory to you, why didn't you challenge the same?
No,
That is why the judge has proceeded.
Milord, please consider, Milord, is it the jurisprudence of our justice delivery system?
Why you do not prefer appeal challenging
But
observations of the court?
please permit me to say this, Milord. I, as a counsel, everybody as a counsel, Milord, makes arguments on the basis of either the pleadings or what has been argued before the court. Milord, in a writ petition or in a suit or wherever, there can be 20 points, Milord, in the petition. And, Milord, the counsel may choose to, Milord, argue only one point. Now the opponent, will the opponent reply to all the 20 points or 1 point?
All right. Yes.
Therefore, Milord, whatever your lordships find over here, and I did not want to go to that extent now that Milord, some discussions are here. Well, my respectful submission is that the findings were not preceded by any arguments of the petitioners. When I take responsibility, please note it down.
Yes. Yes, Mr. Lord.
Yes.
Finished? What?
Not to say, Milord,
No, you have no. What I was saying, it is not that we will shut you down.
yes.
So let us hear your adversaries. Let us get an idea. If you want to contradict, you are there in reply. It is not that we are closing down.
No. But at the same time, kindly also consider this. If I don't convey my points to the court, I don't convey my points to my adversary also.
You have already conveyed.
There are other points also. This findings on the aptitude test and interview.
Very. Then you tell us which are those points, but we can take down that they can argue on that.
Paragraph 9 and 10 of the judgment below, the learned judge holds that aptitude test was not taken.
Noted. Yes.
No pleading on aptitude test. No pleading on aptitude test.
No, the learned judge said that no aptitude test was taken.
Yes.
Then why was this? Why this came that no engagement letter was also sent?
But I have to go back to 1875.
But your case is aptitude test was taken.
Was taken. And not whatever may be the evidentiary value of that so-called spiral, because the aptitude test records were there, the learned judge did not look into it. I cannot
That with us also.
Yes.
কোনটা বলুন কার্তিক বের করো না ওটা কোথায় আছে?
Part of the paper book, my lord.
Yes, sure. Give us that page.
Your lordships may take from page 123. So 123. So please, for example, Millard, take Millard, page 153.
Don't skip your brain.
But these were produced by the petitioners.
Keep your brain.
Huh?
These were Millard part of the spinal fluid.
Part of the spinal.
But this is that so-called spiral by Millard, which was prepared by the petitioners. Now, what are the records so far as the aptitude test is concerned? Please take page 153 onwards. But this is for District of Murshidabad, DPSC Murshidabad. Please take Millard the column headings. Please take the 8th heading column. 8th column from the left, 3rd last from the right. Aptitude test marks is provided.
The aptitude and interview was held on the same date,
Same day,
same venue,
same day,
and same interviewers.
same committee.
Same interview.
Three member interview board.
Put out 2, put out 3, put out 4, put out 5.
And it was spread over various dates.
Various dates because this is district wise. This was done
Now, in every district only one date was fixed.
different dates.
Different dates were there.
But these are produced by the writ petitioners.
Very
Take
good.
one,
Very
take
good.
three, one,
Which
54.
other point you want to show from the judgment?
Ramana, please have a look to me at the rules.
No, you first finish off with the judgment. Which other point you want to say? Then it's up to
On this point, aptitude test is in the rules itself. Just have a look.
that is 2C not 2D was there.
Yes. Which is at page 111.
That an agency may be brought in.
No. That is Millard, the learned judges finding. There's a
এই তো বলেছে এজেন্সিকে ধরে দেখলাম
please take back page 111.
that's a justice. No, where is the date?
Millard, the aptitude test is defined at page 112 under rule 2C. Aptitude test means a test to assess the natural ability, teaching ability
No.
of a candidate.
Just. Is it that one? Page 100. What is this? This page 101, chapter 2, rule 3, rule 4, information of vacancies.
But that is the draft. No, this is the draft rules. No, it starts at page 100.
Page 100. These are the draft rules, yes.
These are the draft rules, but it was finally published, which is the next document.
That is 2016, page 111.
Yes. It starts at 111.
No, what is this then?
Because this is the draft rules which was published in 2050 or prepared in 2050.
No, that's okay. Aptitude was behind that.
But after publication of the final rules,
কিন্তু না না 112টা তো হচ্ছে, এটা তো ড্রাফট রুল হলো।
এটা তো
So you mean to say there were changes after the draft?
No, no, no. The draft rules will not, they have annexed the repetition, therefore, of the paper book. also.
That then in the draft rule, rule 3 does not tally with rule 3 of your fresh rules. Rule 3 is rule 4 is information regarding vacancies.
Yes. No, rule 3,
Rule 4.
বেশি নেই খেলে পারবে বেশি তো খেলে পারবে
but in both rule 3 is role strength of a teacher.
5C.
না বাট এখানে তো অ্যাপটিটিউড টেস্ট স্লো, অ্যাপটিটিউড টেস্টে
না না আমি বলছি ওই এজেন্সি নিয়োগ করতে পারে বলছে না সেটা। You can for the kindly come to your rules page 113,
Yes, ma'am.
information of vacancy subclause 5.
Yes.
With the approval of the state government, the board shall have the following power to lay down the modalities, procedures or guidelines as may be. Engage, clause C, engage any specialized agency for the purpose.
Yes.
So you did engage one company,
So we had engaged a company only for collating the marks, nothing more.
under which provision?
You know,
And not under this provision.
yes, may I clarify this thing? There is a feeling that the agency was appointed for the purpose of selection, interview, aptitude test, etc. The answer is no. The agency that was engaged is only to add up the marks of the candidates, nothing more, nothing.
Under which, where from do you get that authority that I will engage an outside agency for tabulation of marks
It's not a tabulation of marks as
or
such.
adding up?
Yes,
So you must be having some.
but basically, that had nothing to do with the what should I say, the quality of the interview,
So
selection.
so can we take this from you that for there was an engagement of an agency for whatever reason may be,
I'll give that.
but that agency engagement was not provided under the rules. You did not have any authority to do so. আমি তো ভেবেছিলাম এটা
এটা খাইবো
আমি চলো তো বসে রয়েছি না ধরবো বললো
পাশে কারণ
দেখলাম ওইটা আগের কেসটা কত বললো যেন, ওই যে ওই না না 153 বললো না, মানে তোমাকে আমি ইয়েটা দেখাচ্ছি, তাকে এনগেজ করেছি। হ্যাঁ হ্যাঁ 120, হ্যাঁ ঠিক আছে। Then what is page 123?
123.
প্রাইমারি টেট 2014 লিখিত পরীক্ষা 150 ওএমআর শিট তৈরি এবং তার মূল্যায়ন করার বরাত পায় শ্রী এস বসু রায়
এগুলো এদের তৈরি, এগুলো আমাদের কোনো ডকুমেন্টস নেই।
অ্যান্ড কোম্পানি।
আমরা জানি
That is not for the petitioner to explain. This is not. This is part of
Then
the.
which agency did you engage, Mr. Dotto?
Hospitality general question. But I'll check up this point.
Please take up, and subject to what you say, whatever we went into this, as regards agency, this word agency only features under Rule 3, Sub-Rule 5, Sub-Clause C.
Right.
C or D. Apart from that, there is no provision for it. So you will, you have you admit that we took the help of a particular entity for the purpose of very good.
একদম একদম
Yes. Any other thing you want to show us, Mr. Dotto? Finished?
Please have a look at 2 or 3 portions of the rule.
That we will go into, Mr. Dotto. If anything in course of submission, we will hear you.